Good evening, everyone, and welcome back to our webinar series. And this one is on voluntary liquidation. Voluntary liquidation is an important part of IBC, and yes, the good part of these provisions are that otherwise all the procedures that are normally under IBC are where there is insolvency involved or there is more debt than assets involved. Voluntary liquidation is very different. Voluntary liquidation, one has to give a declaration of solvency, but it is still part of IBC, it is still part of the regulations, and it is still a scope that is available to the insolvency professionals. So welcome all of you to this webinar. We have 1.5 hours to take this up. We will start with the regular process where we will start with the PPT. We will then keep taking questions every 20-25 minutes. And the idea is to understand the law. Although the sections in the IBC code, the IBC are few, but then the regulations are many. And of course, the applicability of all the sections with respect to liquidation is also something that we will discuss. So I would say that Anil sir has done a lot of work on on understanding voluntary liquidation, and let us all understand how we can understand this, take this, understand and find opportunities in this as professionals, and also understand this as an option for our clients to close down companies which are not required, where they can save administrative costs, etc., etc.
Thank you, Ankit. Thank you very much. Namaste to all the participants. There was a gap in our webinars, and that gap was only because of the professional occupation and nothing more. We always intend to be associated with our professional colleagues, students, bankers, stakeholders, and this is the good way that we get associated. We have today, along with Ankit, we have Advocate Shalia Agarwal. She's our research associate, and she has done a lot of work on this voluntary liquidation understanding and preparation. So thank you, Shalia, for working on this subject with us. So
thank you, sir.
This subject was it is important because some of the cases were, in fact, when it started, it was thought that it would finish within the limited period, and maximum period was like 6 months or whatever time is required for sale of assets. But it was not being done so. So we thought that it is important that we should study this, and therefore we kind of did this work. So the format will remain as same. We have a PPT on this detailed provisions of voluntary liquidation under the Insolvency and Bankruptcy Code. Also, we will touch upon some of the company law provisions, which can be for striking off. Ankit will also let you know what is the difference between striking off a company under Section 248 of the Companies Act 2013 or voluntary liquidation under Section 59 of IBC. So Shalia will also we would request all of you to put your questions on the Q&A box in this portal, on this Zoom, because this Q&A we will take up all the questions. We understand that there may be many questions. According to our understanding, there are about 1,000 voluntary liquidation which are going on, and not many has been liquidated, completely dissolved. So going forward, we will just try to see what exactly this voluntary liquidation is. When we talk about this Companies Act, this voluntary liquidation under Section 59 of the Insolvency and Bankruptcy Code, then we used to have some voluntary winding up provisions, which was the voluntary winding up by the shareholders. And then we also have seen section 270 of the Companies Act 2013, which is also the winding up provisions. So with the introduction of IBC, the provisions regarding voluntary liquidation from the Companies Act were repealed and inserted under section 59 of the code. And this is 59 of the code, and the regulations were also made, IBBI Voluntary Liquidation Regulations 2017, which came into force on 1st April 2017. We have also seen that Rule 4 of the Transfer of the Pending Proceedings Rules 2016, which was notified on 7th of December 2016 and brought into force from 1st April 2017, stipulates that all applications and petitions relating to voluntary winding up of the companies pending before High Court prior to 1st April 2017 shall continue to be dealt with by the High Court as per the provisions of the Companies Act 1956. All fresh proceedings for voluntary winding up on and from 1st April 2017 shall be introduced before NCLT and shall be governed as per the provisions of the code and the regulations. So therefore, when we see this voluntary winding up, section 484, voluntary winding up of Companies Act 1956, and voluntary winding up under section 270 of the Companies Act 2013, these are still prevailing, and because these cases are still being dealt with by respective high courts. Then later on, there was an MCA notification dated 29th of June 2017, where the transfer of proceedings related to cases of voluntary winding up to NCLT. And the notification says all proceedings of voluntary liquidation of a company where notice of the resolution by advertisement has been given under section 485 of the Companies Act 1956, but the company has not been dissolved before 1st April 2017, the liquidator shall make an application for dissolution directly before NCLT. So this was regarding the section 485 of the Companies Act. And any understanding about section 270 of the Companies Act 2013? Was that also part of this notification, Ankit or Shalya? And otherwise we can even wait for some time, and in the meantime we can study, because this notification only talks about section 485. That means it is only talking about section 484 of the Companies Act 1956. We need to see whether section 270 of the Companies Act 2013, whether that was also covered by this notification dated 29th of June 2017. That's, of course, this is one thing which is pending, and we'll handle this question whenever it comes. In case you have the answer, you can speak now, or we can even wait for some time.
So in the meantime, I will look for this and we'll answer this during our session.
All right, okay. So as we all are under we are in profession of chartered accountancy, consultancy, we have seen there are many reasons for where the companies are required to be liquidated. And the reasons may be the accomplishment of the purpose for which the company was incorporated, because there are some companies which are incorporated for a particular purpose, maybe for a joint venture, maybe for taking up a contract, maybe for taking up a supply, maybe. So for there may be some accomplishment, and if that purpose is accomplished, then the company needs to be liquidated. Articles provide the company to be liquidated on happening of an event. So there may be a scenario where a company would be liquidated on an event which is mentioned in the articles of association of that company. Company is unable to carry on the business, make profit, non-viable. So anyone can say that this company was into a business, and this that business is no more viable, or the business is maybe some regulatory issues that the business cannot be done. Unfeasible operations or poor operating conditions, departure of company founder or any key executive. These are some of the reasons. I think Ankit and Shalya can add more reasons why the companies are supposed to be liquidated voluntarily. We are only talking about voluntary liquidation where the company has sufficient funds to pay off its debt. I mean, we'll come to that definition, but what are the other circumstances where you feel that the uh, promoters may like to liquidate the company, uh, where the where there is no default of payment to the creditors? I think maybe many such reasons would be possible. Uh, Now, let us see this voluntary liquidation. What are the provisions under IBC? One, that it is only one section. It is only one section provision, section 59. But when we read section 59, it also says that for voluntary liquidation, section 35 to section 53 of the chapter 3, that is the liquidation process, that is also applicable to all the voluntary liquidation processes. Now, when we see this section 35 to section 53, even 43, 45, and 50 is also part of this series. Between 35 and 53, we would also see section 43, which is the preferential transactions, section 45, which is the undervalued transaction, sector 50, which is the extortionate credit transactions, and even section 49, which is basically the undervalued transaction with fraudulent intent. Then section 68 to 77A, which is all related to offense and penalties, that is also applicable. It is very clearly mentioned that it is also applicable. Then the IBBI has issued regulations, voluntary liquidation process regulations 2017, and there are regulation 1 to 40. So this is a complete law on voluntary liquidation of the companies under IBC. Okay, so let us first of all see this section 59, the preliminary requirement for voluntary liquidation is a corporate person. Whenever we say corporate person, means that the corporate debtor means any company or corporate person, even includes the limited liability partnerships, who intend to liquidate itself voluntarily, has not committed any default, may initiate voluntary liquidation. One, that it has not committed any default, and therefore the voluntary liquidation can be initiated. This is the very first condition. This is a very, very preliminary requirement of voluntary winding up. Any company which has defaulted on payment of debt will have to go first the corporate insolvency regulation process and then liquidation process. However, where there is no default, where there is no resolution required, therefore there is no corporate insolvency resolution process. So it is directly going to voluntary liquidation. So the first requirement is that there is a declaration which is required to be given by the directors of the company on an affidavit, and which says that they have made full inquiry into the affairs of the company and they have formed an opinion that either the company has no debt or that it will be able to pay its debt in full. It will be able to pay its debt in full from the proceeds of the asset to be sold in voluntary liquidation, and the company is not being liquidated to defraud any persons. So therefore, basically the three conditions that the directors have made. First of all, there is no default. Second, the directors have made full inquiry into the affairs of the company. Later on, they cannot say that there was a mistake in our inquiry. Of course, there are provisions, like in case they found that this company's total liabilities have gone up or the assets have gone down, so the company is not able to pay its all its debts, then all this voluntary winding up process would be closed and the company will go to CIRP. Then they have formed an opinion that there is no debt or it has the assets which are sufficient to pay off its debt, and the company is not being liquidated to defraud any person. So these are the basic conditions for initiating voluntary liquidation. And when we take a decision, when this kind of declaration, when this kind of opinion is formed, Then the documents, what is required is audited financial statements, record of business operations of the company for the previous 2 years or for the period since its incorporation, whichever is less. So in case a company is only incorporated a year before, then the record of business is only for 1 year and the audited financial years also for as maybe 2 years or for the number of the existence of the company, whichever is less. Report of the valuation of assets of the company, if any, prepared by a registered valuer. So this valuation is not really important, but if there is a valuation, that has to be attached, that has to be submitted. So these are the documents required for initiating voluntary liquidation. Now the process, because see, we have 1.5 hours and the subject is very large, because we understand there are some judicial pronouncements also. We also need to compare with the striking off option under the Companies Act 2013. That also we have to discuss. Then we will discuss under what circumstances the striking off is better, or under what circumstances the voluntary liquidation is better, because this is all that subject that we wanted to take care today. The first step is convene a board meeting, submission of the declaration to ROC along with the attachments. So that is the first step. So within the 4 weeks of the declaration, a special resolution is also required to be passed that the company be liquidated, and that is in the meeting of members of the company, and in this particular meeting the insolvency professional will be appointed as liquidator. Insolvency professional will be appointed as liquidator even in the voluntary winding up, voluntary liquidation, or in liquidation. The name of the liquidator remains same. It is a liquidator only. So even the power is also the same. The liquidator has the same power as the liquidation under the IBC or voluntary liquidation. Then approval of creditors holding 2/3 value of total debt of company in case of any pending debt. So in case there is no liability, no such requirement of approval of creditors. However, if there are creditors in the balance sheet of the company, then 2/3 creditors by way of value, they would also approve that the company be liquidated. Then when all these 3 things are done, like board meeting, members meeting, special resolution, appointment of liquidator, approval of the creditor. When all this is done, then intimation to ROC and IBBI within 7 days of the resolution of creditors. Within 7 days of resolution of creditors, we have to inform ROC and the IBBI within 7 days. That is called the process is started and the public information has gone in this regard. Public information means ROC and IBBI. Now the section 59 subsection 4 says upon approval, liquidation proceedings against company deemed to be commenced from the date of such resolution. So the date of commencement would be the resolution, with the special resolution passed in the meeting of members of the company, and the date of approval of creditors is not relevant. However, the liquidation process will start only after the approval of the creditors, but the date of commencement will be considered as the date of the special resolution which is passed. So therefore, the IP is appointed as liquidator of the company after all this is done. The IP is appointed now. So we've done this board meeting, special resolution, IP appointment, creditors meeting, information to ROC, IBBI, and now it is the company is considered to be under voluntary liquidation, and the date of commencement is the date of passing of special resolution in the meeting of members of the company, and the IP is appointed as a liquidator. Now coming to the stage 2, that was the stage 1. Now coming to the stage 2 of the process, first there will be a public announcement of voluntary liquidation. So therefore, it is an invitation for filing claims. It is an invitation for filing claims. And then second step is the intimation to the assessing officers under section 178 of the Income Tax Act within 30 days of appointment of liquidator. So in case the Income Tax Department has to quicken up the assessments, they can do that. In case the income tax department has to quicken up some of the assessments, some of the demands, they can do that, understanding that the company is going for voluntary liquidation, so they should not lose any tax after the company is dissolved. So this is something which is a prior information to the income tax department, so that they should be ready with the whatever they have as pending dues of the company. Preliminary report is required to be submitted within 45 days. Verification of the claims within 30 days from last date of receipt of claims. Preparation of list of stakeholders within 45 days. So, public announcement, number one. Then receiving claims and verification of the claims. Then preliminary report within 45 days and preparation of list of stakeholders within 45 days. This is all the part of the process. Opening of the bank account, which will be operated by the liquidator, and then realization of assets and distribution to the creditors, and the submission of final report to ROC and IBBI, and application to adjudicating authority seeking dissolution. This is the in one shot. We are just trying to tell you this is what is the process. So the public announcement, claims, and the verification of the claims, and then the preliminary report, and then the preparation of the list of stakeholders, asset realization, distribution, and then final report to ROC and IBBI, and application to adjudicating authority for seeking dissolution of the company. Submission of the adjudicating authority, submission of AA order to ROC within 14 days of the receipt of the order. So that means once the adjudicating authority passes an order dissolving the company, and that order is informed to ROC, that means that the company is fully dissolved. So Ankit, this is the overall procedure. And then I think you can see in case there is any question, but then after some time also.
We can take some questions in a while. Maybe you can just complete the first preliminary part and then we can take up questions.
All right. So then we need to see the effect of voluntary liquidation. Now the process has been started from the date of passing of special resolution in the meeting of members of the company. What is the effect of commencement of voluntary liquidation? So let us see the effect. The corporate person shall, from the liquidation commencement date, ceases to carry on its business except as far as required for the beneficial winding up of the businesses. So the beneficial winding up can be because see this there is nothing like sale of the corporate debtor as a going concern, because in case it has to be sold, it will be sold as a business, because there is no provision of sale of the corporate debtor as a going concern. However, the business can be sold to someone. Business can be sold to someone as a going concern, and all that money can be received and can be paid to the creditors and to the shareholders. However, in case some income is coming to the company, that income will continue to come. If some rental income is coming, that income would continue to come. And in case there are some things which are required to be continued only for getting better value of the assets, that will also continue. The corporate person shall continue to exist until it is dissolved under section 59(8) of the code. So now what this line means? This line says that all obligations of a company will continue, even if the voluntary liquidation has been started, but all the obligations and rights of a company would continue. The powers of the board of directors, key managerial personnel, and the partners, in case it's an LLP, as the case may be, may continue to exist during voluntary liquidation process to monitor the process, approve the manner and mode of sale of the assets. Now, let us see, in this case, the board of directors has all the powers. Key managerial personnel has all the powers. The partners of limited liability partnerships has already all the powers. May continue to exist. They will continue to exist. However, why the word may is written here? Because there may be some cases where the board decides, shareholders decide that now after this special resolution, the board of directors will not have any power. So all the powers will be exercised by the liquidator. Because see, there may be some cases where the directors are not shareholders. So the shareholders may decide, in case there is a trust deficit somewhere, they can decide that all the powers would be with the liquidator. So what all the powers board of directors still enjoy? They enjoy the process. They will monitor the process. They will approve the manner and mode of sale of the assets of the corporate person by the liquidator. So, however, the entire process of voluntary liquidation relies on the liquidator, and accordingly, the liquidator is given significant powers. Since the liquidator is entrusted with significant duties and powers, it is expected that he will perform its duties and morals and ethics along with the company compliance of law. That's what, of course, without saying, it is required. Powers of the liquidator vis-a-vis board of directors of the corporate person. As I said, that this powers of the board of directors, the key managerial person, may continue, and the liquidator has been given the powers, legal as well as moral responsibilities. That is something which is like in most of the cases we have seen in this Indian environment, we have seen that in fact the stakeholders, in fact the board is still driving the process, and the liquidator is working along with the board of directors. The liquidator is a fully regulated person. The liquidator also understands what are his powers and the duties. Section 33, we have seen, this is very important, that again I would remind all of you that section 33 to 53, section 35 to 53 of the liquidation process of the IBC is applicable to voluntary liquidation cases. Okay, now as far as this who can be the liquidator, the board member will appoint the liquidator. It has to be an insolvency professional. They have to decide. The board of directors will decide about the remuneration payable to liquidator. The liquidator, the insolvency professional, will intimate IBBI within 3 days, and the insolvency professional shall be completely independent to the corporate debtor. The remuneration of the liquidator will form part of the liquidation cost, and the board of directors. The board of directors also has power under Regulation 6 of Voluntary Liquidation Regulations issued by IBBI. They have the power to replace the liquidator and appoint any other insolvency professional by a resolution passed under section 59(3)(c). 59(3)(c) is a resolution. 59(3)(c) is a resolution by members. So the members of the company, they have power to replace the liquidator also, in case they find that the liquidator is not functioning as desired under the law. So they can even replace it because the company continues, the board of directors continues, the shareholders continues. They can have meetings. They will have all kind of as such the company will continue till the time it is fully dissolved. So they will continue to hold board of directors meeting. They will comply with all the requirements of company's law. So everything would be done as if the company is continuing. So when we see these powers and the functions of the liquidator and the duties of the liquidator, one, that the Regulation 8 to 14 says very clearly that the liquidator shall prepare and submit to adjudicating authority following reports. So these are the 4 reports which is required during the entire process of voluntary liquidation, preliminary report, annual status report, minutes of consultations with stakeholders, and final report. So one by one, in case we see this preliminary report, and we have also seen that the preliminary report will also have the list of creditors that is required to be given within 45 days from the liquidation commencement date, and should contain capital structure of the corporate person, estimates of assets and liabilities, intention to make any further inquiry into any matter relating to corporate person or its business, proposed plan of action, timeline, and estimated cost. So as we have seen in the liquidation processes, even voluntary liquidation process also requires many registers and books of account, which is required to be maintained by the liquidator. In case the books of accounts are incomplete, then it is the duty of the liquidator to get the books of accounts updated. And there are many registers which are specified in Schedule 2 of the regulations, which is required to be maintained by the liquidator. And the liquidator is also supposed to keep all the receipts of payment and income during the liquidation process. Liquidator can also engage professionals during voluntary liquidation process, and the professional should not be related party to the liquidator. The remuneration of those professionals also would be a part of the liquidation cost. However, whenever we are appointing professionals, we have seen that the board of directors or the shareholders, they would have their say. Like we have the process of consultation with the stakeholders as per regulation 12 of the voluntary liquidation cases. The stakeholders shall extend all assistance. Similar provisions are there, but that was in the code. This is in regulations, that the liquidator can seek assistance from the stakeholders and can have meetings and shall maintain the particulars of any consultation. That means it has to be minutized. This, although it is very clearly said that section 35 to section 53 of the code would be applicable to voluntary liquidation cases. However, the regulation also says that a transaction shall be considered as an extortionate credit transaction. Wherever there is an extortionate credit transaction under section 50 subsection 2 of the code, again the same definition requires the corporate person to make exorbitant payment in respect of the credit and unconscionable under the provisions of the law relating to contracts. So now I think we start the process. What we've done so far, all this is the powers of the liquidator and all that is required. That's what we've done. And now it's the process in detail. Public announcement has to be done. So I'm not spending time on this public announcement. So the public announcement has to be done within 3 days from the liquidation commencement date. And also it has to be given on the website, which is now maintained by IBBI also. So in this case, we also would like to see that there is an IBBI order passed against one of the insolvency professional, where the public announcement in the newspaper was made after 18 months. The public announcement in the newspaper was made after 18 months, and the regulations were also in like mentioned, and the IBBI has imposed a penalty of 1 lakh on the liquidator for making this contravention. So in case if it is required 3 days, so the IBBI has passed one order where the penalty of 1 lakh was imposed because this public announcement was delayed by 18 days. Okay, now this public announcement has been done, and let us see the other powers of the liquidator. Now these powers are mentioned in section 35 onwards. Section 35 onwards. The liquidator has to verify the claims, to take into his custody or control all the assets, to evaluate the assets and property of the corporate debtor, to take such measures to protect and preserve the assets and properties of the corporate debtor. Now, this part, to take such measures to protect and preserve the assets and properties of the corporate debtor, that is very clearly mentioned here. Now, in case, although the liquidator has to work with the corporate debtor in voluntary liquidation cases. However, in case he sees any risk on the assets of the company, it is his duty to protect and preserve the assets. He is also supposed to carry on the business of the company for its beneficial liquidation, and he will sell the immovable movable property of actionable claims of the corporate debtor in liquidation by public auction or private contract, to draw, accept, like the bank operations, and other powers as mentioned in the code as applicable to the liquidators. So all the powers of the liquidator as mentioned in the code is applicable to liquidators who are handling the voluntary liquidation processes. So now, so there are some questions here that we can see. The questions like whether the liquidator can file an application for non-cooperation under section 19(2) or under section 34 subsection 3, because see, the section 34 subsection 3 is because see, the section the applicability is only coming from section 35. Does not where any promoter or any key managerial personnel is not assisting or cooperating, the liquidator may make an application to the adjudicating authority for necessary directions. Section 34 subsection 3 read with section 19(2) of the code. So that's one question which we feel that yes, if a cooperation is required, and it is the duty of the personnel of the corporate debtor that everyone should cooperate. Okay, now the claim verification is a very big chapter. I would like to see whether it is to be done completely or not. So Ankit, like, can we take some questions?
Before that's what I was saying, that before starting the claim verification process, we can take up the questions that we have received so far. And
Right.
basically, I will start with the first question that we received, and then I think that is the way we will take it up. Mansaj Aryaji is asking, what if any statutory claim of GST arises after liquidation commencement date and company does not have the funds to meet the obligation? Will the NCLT order dissolution in that case? Can liquidator make an application for liquidation under section 59? So voluntary liquidation, the solvency has to be there. In this case, I believe Mansajji is suggesting that the company is insolvent and the funds are not available to meet the obligations. So that would only what is the I think we need to talk about what happens in case the voluntary liquidation starts or is started by NCLT and it is later revealed that the company is not a solvent company.
See, in case the voluntary liquidation process is not completed the way it is provided in the law, then this process will be terminated. Now the company is not able to complete the liquidation process. That means the company is a normal company, and a normal company, for making payment of its obligations, either the normal company will go for CIRP or they will make arrangements for payment of the GST. However, this liquidation process would not be completed and the company would not be dissolved in case the liabilities are not paid. Alternatively, when we see this new proposed regulations, and also we see the section 248 of the Companies Act, where the striking off is possible for companies not doing any business, we have seen that the stakeholders can also take up this responsibility that they will pay, and they can own that obligation, and they would be personally responsible for making that obligation met. That also is one of the solution which has been found, and the adjudicating authority can pass such order that the so and so person would be responsible for making these payments. In case it has to be provided for, or like it has to be paid. That's what is. I will come to that question because that's a very, very important question. In fact, many people are going to ask this question, and I fully understand that. So the question which we are going to attend today is like this: like in case the matters are still pending and the assets are also there, but the liabilities are not crystallized so far. Second, some of the liabilities are crystallized and the liabilities are now more than the assets. These are some of the questions that we are going to handle, and we will come to that appropriate thing. So we'll wait for some time to find this answer. Ankit, we can move forward.
We can move to the next question perhaps. So the next question is, can microfinance company undergo voluntary liquidation? From Mr.
I
Anil
think this,
Rajput.
all the insolvency and bankruptcy code is not applicable to financial service providers.
Right.
So financial service provider, the code is not applicable.
Wherever there is a special regulator, whether it's insurance or RBI involved, then the permission is required from under those statutes. And I believe one has to go to those statutes and see how the winding up can happen or the liquidation can happen.
Only RBI has powers. If
only
this
RBI
company is regulated by RBI, the RBI has power.
In case of insurance company, the IRDA or the, so basically
yes.
the powers are in the respective special acts. So this is what I understand. Mr. Chidambar Chikrur is asking that IBC law is emphasis on credit control management and going concern. What is reason for bringing voluntary liquidation into IBC law? Why not only in MCA? So I think voluntary liquidation is a process which is concerned with liquidation. So the thought process, in my opinion, must be that when IBC is talking about and creating professionals in the field of liquidation, then why not also allow voluntary liquidation to happen through those professionals, through the same framework? And I think that is what you also talked about, that although the section is only one talking about voluntary liquidation, but it refers to the complete chapter on liquidation and talks about how the two are connected and how the entire process talked about in the liquidation process is supposed to be conducted by the liquidator for voluntary liquidation as well, or parts of it are required to be conducted. So maybe you can also share your views, Shalya and Anil sir.
Yes, I believe that it is true because all the powers of a voluntary liquidator is same of that of a liquidator under the liquidation process.
So that would be the idea behind putting this under IBC.
Right, right.
Absolutely, absolutely. I think it is very clear that first of all, it is the need of the era that every entrepreneur has a right to exit the business. Yeah. It is the need of the era that the right to exit a business is very, very important, because the right to start a business, the right to exit a business. The voluntary liquidation under this code, it was supposed to be a very, very quick process. So there is a framework which is already made. The regulated professionals are available. So why keep some things before the High Court and keep some things before the NCLT? Because see, this the creditors voluntary winding up or shareholders voluntary winding up, this was a very, very old matter. It's not a new thing. It was in Companies Act 1956. It was in Companies Act 2013 also. And there are many such voluntary winding up cases which are initiated, and it was not even finishing in 20 years. I have personally seen voluntary winding up cases which are continuing for 20 years. And this was a process which, in fact, it was thought that this will finish within this will finish within 1 year. It is actually happening in some cases, but yes, in between there was a difficulty in getting the NOC from the Income Tax Department, where IBBI clarified that no NOC is required from the Income Tax Department. Now this proposed amendment into voluntary liquidation cases, proposed amendment by IBBI, you would see that the IBBI is trying to make it very clear that even if some of the liabilities are not crystallized, it can be provided for and the company can still be dissolved.
I think that's a very valid point, that the older provision, the whole process of going through the official liquidator concept was a very time-taking process. And as part of the ease of doing business framework, you're not only talking about making it easy for insolvent companies to just like liquidate and disappear from the area, but you also want those companies to disappear which are not required, or which are not required to be taken up or taken forward by the promoters. So let's move on to the next question. We have quite a few questions. We'll just complete all these because these have accumulated. So Navdeep Gupta ji is asking, in case where there are no fixed assets and assets are only in the shape of bank accounts and fixed deposits and other current assets, whether we need the valuation report. So the valuation report is required in all cases. I don't think there is an exception there.
No, valuation report is not required. Sorry.
Not required in this case.
Valuation report is not required. I mean, valuation report is only it's only to be submitted to the adjudicating authority in case it is done. Like in case no valuation report is required, it is very clear that it may or it may not be required. So it depends upon the nature of assets, and it is otherwise.
So if the nature of assets
mandatory.
are such that Navdeep ji is suggesting, then you're saying that it is not mandatory. Okay.
It is not required.
Also, under section 79, the directors are obligated to file all the list of assets which the company has before that. They have to give a declaration in this regard. So even that can be done.
So Sankaran ji,
79 of?
So in section 59, they have to submit a declaration.
59. Right, section 59, yeah, declaration, yes.
Sankaran Rajagopalan, so Sankaran Rajagopalan ji is asking that whether sale of business of the CD or as a going concern finds a place in voluntary liquidation.
Yes, I already said selling the company as a going concern, which is
business as a going
concern
32. Business as a going concern, or the company also.
I know. As per regulation 32 of the liquidation process, that is not possible, because once this voluntary liquidation process starts, it has to end with the dissolution, and the sale of the business as a going concern is possible. Sale of the company as a going concern is not possible. Now, in case the company goes for voluntary liquidation process and the entire business is sold to somebody else, and then the company would be dissolved. Now, when I say the business would be sold to somebody else, that means the entire business in a lump sum manner is sold to someone against money. That money would be paid to the creditors and shareholders, but not the company as a going concern, where the company is transferred to somebody else. That is not something which is covered under voluntary liquidation processes.
Next question that we have is from Mr. Rajiv Dhingra. So he says that such companies have accumulated losses due to which in all likelihood solvency or ability to pay full liability will not be there. What would be the fate of voluntary liquidation? So voluntary liquidation in these cases is not applicable, because insolvency, if it is an insolvent, so it cannot start. Voluntary liquidation cannot start for insolvent companies. Anil Rajkot ji is asking how to resolve issues pertaining to disputed creditors, disputed debtors, refund due from income tax department, and litigated matters like cases by and against the company. There has to be quantification by maybe a valuer of all these liabilities, and perhaps then the voluntary liquidation can start in case the solvency is still established. Maybe your call, you can answer this on what would be the practical aspect.
This is a very important question, and most of the difficulties which liquidators are facing today is basically the kind of contingent assets, contingent liabilities, uncrystallized liabilities, and with the liabilities pending assessments, pending appeals, pending arbitrations. So all these are issues presently and the law is very clear that all the debts has to be paid or provided for. In case the liabilities are of such nature that it can be assigned to the stakeholders, shareholders who are getting some amount from the company's assets, then of course it can be provided for and the company can be dissolved. So I will come to that point because see, this is something which is very important. I mean, as I said, pending disputes, pending liabilities, uncertain liabilities, all that will definitely attend to this issue.
So moving on to the next question, who will sign the annual balance sheet? Can directors sign along with liquidator? I believe once the voluntary liquidation process is started, the balance sheet preparation is then for the financial statements.
Ankit, it is very clear that this voluntary liquidation process commencement would not impact on the company in any manner. It will continue. All the obligations of the board of directors would continue. All the obligations of shareholders will continue. All the compliances would be the obligation of the collective responsibility of the board of directors and the liquidator.
So the liquidator will jointly sign with the directors the financial statements,
yes,
or will it be the duty of the board of
liquidator-
directors and the shareholders?
No, I think the liquidator can always say that since the board of directors are continuing, the liquidator and the board of directors is primarily responsible for this, for the financial statements, for the books of account, and for all the auditing and all the compliances. Primarily, the board of directors is responsible. The liquidator's responsibility is secondary because the board of directors exist unless the special resolution which is passed by the members of the company, they would make the liquidator as wholly responsible, and they would say that the board of directors would not have any power. So that is practically possible. That is legally possible. See, that all depends upon the members, what they have resolved in special resolution. In that special resolution, they can always say that the board of directors would not have any power, and the entire process would be conducted by the liquidator. And the whatever proceeds would be, it will be distributed to the stakeholders. After the creditors, it will be distributed to the shareholders. Because in many companies, the board of directors are professional directors, and maybe that there are some disputes also in some such companies. So the shareholders may decide to liquidate the company and take away their money. So in those cases, they can even decide that the board of directors would not function during this liquidation process. So this is my view, and yes, it is possible that board of directors may not function. I mean, that depends on the special resolution. However, in case the board of directors is functioning, then the board of directors are primarily responsible for financial statements, and the liquidator is not responsible.
And I believe in that case, the directors, the managerial staff, they can even draw salaries if they're executive directors or they're employees in the company.
Absolutely.
All that process will continue.
They can draw salaries. They can take meeting fee. They can take sitting fee. They can take the committee membership fee. So they will continue as it is.
Can new directors also be appointed during the liquidation process in case existing directors resign during the voluntary liquidation process? That's another question that we have from Mr. Birendra Tripathi.
I think that's not perceived because once this board of directors decides to liquidate the company, in case they also think that any change is required in the directorship, they can do it that way. However, as I said that all the company law provisions are applicable during the liquidation process. All the powers.
So in that case, this eventuality arises that the directors are less than 2, then maybe
yes,
directors can be appointed.
Then directors can be appointed, director can be even resigned, directors can even go away. That everything is happening. All the returns of ROC would be required to be filed till the time the company is dissolved.
So Mr. Bhaskar Shetty had asked that when will AA adjudicating authority come into the picture in voluntary liquidation? I think we've already answered that and through the process that we talked about after this question was posted. Puff transactions.
First report, I said the first report which is required to be submitted is the First is that IBBI should be
report,
informed.
yeah.
Then the first is the preliminary report and the list of creditors. This is all, it has to be finalized. That is the first thing which the NCLT is appraised about.
So I believe next question is that with respect to puff transactions in case of voluntary liquidation, how does the liquidator talk about that? So you can, I think, talk about that briefly, and I can in the meantime look at other possible questions which are not repetitions of the questions we have asked so far.
I just wanted to handle this puffet transaction slightly later, because see, this is very important subject today, and I would like to spend some time on this.
So we will take it up later. Then
questions.
we will take it
I
up
will
later.
take it up later. But puffet transactions is very, very important, as I've already said, that section 35 to 53 of the code is applicable to voluntary liquidation processes. Therefore, section 43, 45, 49, 50, all are applicable. All are applicable to voluntary liquidation cases. I will quickly take you through the claim verification. Claim by operational creditors to be submitted in Form B, in person, by post, or electronic means. All those kind of evidences, whatever we have seen in the liquidation processes, there is no change in this. Similarly, financial creditors will submit their claim form in Form C as per Regulation 17, and all, there is no change in the voluntary liquidation or the liquidation processes. Workman and employee will submit their claims in Form D. No change in the. See, the only one thing which is common, because this is claim verification, is completely same as in the liquidation process or in the voluntary liquidation process. In liquidation process also, in case workmen or employees, they do not submit their claim, and the books of account show that there is some amount payable to workmen and employees, it is the duty of the liquidator as well as the voluntary liquidator to admit such claims as appearing in the books of account in case the employee or workman has not submitted any claim. Now, this is the Form F, which where the claim by stakeholders. These are like other than operational creditors, financial creditors, workmen and employee, and these are the other stakeholders, and this also includes the shareholders. This also includes the shareholders. The claim is also to be filed by the shareholders, and to clarify it, there is no difference. Even in the liquidation process or in the voluntary liquidation process, the shareholders can file their claims, because there may be many companies in the world that where the even after the default, there is still some amount which is left for the shareholders to pay, because the liquidation process or the default, that is a matter of mismatch of fund flow. However, it is always possible that in some cases the shareholders also get some money when the business is closed and the assets are realized. So when we talk about the verification of security interest, same as we have seen in the liquidation process, information utility, the charge admitted by registrar of companies or CERSEI regarding the bill of exchange, promissory notes, substantiation of claims, cost of proof, all are similar provisions regarding verification of claims. Contingent claims, it's same provisions as in liquidation. Debt in foreign currency, periodic payments, debt payable at future date, mutual credit and set off, no change at all. Word by word, it is the same as in the liquidation processes. So I'm not spending any time on this, because this is something which most of us must have done in either in liquidation or in voluntary liquidation. So the this mutual credit and set off explained at the Honorable Supreme Court in Swiss Ribbon versus Union of India observed that a set off may be considered at a stage of filing of proof of debt while initiating a resolution process by the resolution professional. However, the possibility of its application after the filing of the resolution petition or initiation of the CIRP was answered negatively by the Honorable NCLAT in the manner of Vijay Kumar versus Bharti Airtel. So this was the observation in the Vijay Kumar case, that the concept of set-off is as equivalent to making a preferential payment over other operational creditors. No dues can be recovered from the corporate debtor when moratorium imposed under Section 14 of the Code is in force. While deciding disputes on counterclaims or set-off, NCLAT requires the determination on the following: whether there was a mutuality between the parties or not, whether the set-off was done before the initiation of CIRP process. In case of deviation from any of the aforesaid prerequisites, the courts and tribunals have a right to term set-off as invalid. So as I always say, that you cannot come later that I have some liability, I have some assets, I have on some account I have to take some money, on some account I have to give some money. It has to be done at the time of filing of the claim and not later on. So like you can't even set off between two parties. The most important part is like in case there is some kind of a security deposit in the same with the same party and some kind of transactions account. So when in the case of any CIRP or liquidation, then somebody can definitely set off these two and file their claims. Somebody can set off these two and file the claims. So this is what is the mutual credits, which actually we can explain. So the verification of the claim is to be done again in 30 days. Admittance of the claim after the verification, rejection is also can be done. And the claim admitted or rejected, the liquidator has to record reasons in detail, because there was a NCLAT order in May 20 that not assigning reasons, and that too in a rejection order relating to a claim, is not prudent and reasonable course of action. In respect of interest, merely stated that as per contractual agreement, there was no provision for an interest and hence not considered, are incorrect and illegal, untenable in the eyes of law. So whenever the liquidator, maybe voluntary liquidation or liquidation process, the liquidator has to give reasons for rejection. Maybe for admittance, it may not require as detailed reasons, but for rejection, it is required to give a detailed reason. And therefore, because the other party also has a right to appeal against the order of the liquidator rejecting the claim. Regulation 29, sub-regulation 2, again says that the creditor has an option to file an appeal to adjudicating authority against the decision of the liquidator within 14 days of receipt of such decision under section 42 of the code. And this is also, here we found one case law, that was Harish Khurana, liquidator of TEIL Projects Limited versus Engineers India Limited. And this was the appellate authority order in May 20. Admission or rejection of claim falling within the ambit of section 40 of IBC lies within the domain of the liquidator, and decision of the liquidator rejecting any claim is appealable before adjudicating authority. Section 42 provides for remedy of appeal against the decision of the liquidator, accepting or rejecting the claims, as also voluntary liquidation of the corporate persons are governed by section 59 of the IBC, incorporated in part 2 of the IBC. Thus, the appeal under section 42 before the liquidator, as also the instant appeal before this appellate tribunal, are maintainable. So the list of stakeholders again has the similar provisions. There is no change. The liquidator has to prepare this list of stakeholders category wise. It has to be filed before the adjudicating authority within 45 days. The filing of the list has to be announced to the public in the manner specified in regulation 12(3). The liquidator may apply again in case of change or modification of any entry into the list of stakeholders. It has to be modified on an application filed to the adjudicating authority. Whenever it comes to an additional information, the liquidator shall only modify the list as directed by the adjudicating authority, and the list of stakeholders as modified from time to time should be available for inspection by the person who submitted proof, available for inspection by the members, partners, directors, and guarantors of the corporate debtor, and it is displayed on the website of the corporate debtor. So now we actually while we'll move on to the manner of sale and the sale of assets, recovery of assets and distribution, we need to see is there any relevant question at this stage, Ankit? Because we have done this verification part of thing, but then yes, this now the sale process is going to start. Shalya, could you see anything that we should add?
No, sir, I think we have added all the relevant parts in this.
One question with respect to claim that I have is that whether shareholders of the corporate person need to submit the claim form.
Yes, the shareholders are also supposed to submit their claim of the shareholding. Like, see, there are two opinions. One, everyone says that as far as the shareholding of the company is concerned, the company has the best records. The company has the best records of the shareholders, because see, this is all the company will have the list of shareholders, all the documents. So the claim of the shareholders is not very important. However, it is in the voluntary liquidation, I have seen that some of the documents which are required for Form F, that also says that the demat account of the shareholders. Therefore, the shareholders also can file their claim. However, I also say that in case the shareholders are not able to file their claims, that doesn't mean that the liquidator will not distribute to them, because the liquidator has more authentic information in the books of account of the corporate debtor regarding the shareholders and the authenticity of the shareholding. So therefore, even if the claims are not filed by the shareholder, I believe the liquidator would not be able to say that you are not entitled to any dividend if there is amount available after payment of creditors. However, in the case of liabilities, in the case of debt, if no claim is received and thereafter the liability can be considered as not payable or waived off. Yes, Ankit.
So another question that we have here is that once voluntary liquidation has commenced, can it be rolled back due to changed circumstances? The change circumstances in most cases is that some people are saying, say, the directors have changed. Somebody who was driving the voluntary liquidation process now is no more, so somebody else is now at the helm of affairs and they have a different idea. Maybe it is taking too long for the process to complete. It is now under dispute. So maybe we can talk about instances when voluntary liquidation process has been started by a company and then it has been requested for a rollback or requested for cancellation.
So
I will attend to this question. Shalya, in case you have, otherwise I will attend to this question little later, because see, we have
covered this topic in our presentation.
We have covered this topic in our presentation,
right.
And this rollback, or if the company is from this,
because there can be many things.
into insolvent.
Yeah. So it has become insolvent, a new liability has come up because of which now voluntary liquidation is not feasible, directors have changed. So there can be many reasons.
Assets have impaired, the value of the
events that have happened after the voluntary liquidation was started. So when it was started, maybe the directors, shareholders, everyone believed that no, this is a solvent company, but that can change. Other things can also come in. So we can maybe deal with that question. That is a standard question.
We have covered this. This is a standard question. I know this question is a lot more important. So we have covered this information. Because see, it was also very important that we should explain the entire process, of course, quickly, because this we can't have 2 sessions on voluntary. This is not a very.
We will also then I think perhaps spend about 5 minutes on how voluntary liquidation is different from the winding up process under Companies Act or the strike off process. So that's something that I can talk about briefly once we are done with the PPT. Let's proceed then.
Now, the liquidator, this is a manner of sale, Regulation 31. The liquidator may value and sell the assets in the manner and mode approved by the corporate person in compliance with the provisions. Provisions has to be complied with. However, the manner of sale and the value, all that has to be approved by the corporate person. Here, I definitely would have something in case the liquidator see that the assets of the company are being sold by the corporate person and the liquidator can see some undervalued transactions, then it becomes the responsibility of the liquidator to protect the assets, because section 45 is applicable to voluntary liquidations. This is very important. Section 45, section 50, section 49 and section 43 is applicable. Now somebody says that the preferential transactions, how does it applicable to voluntary liquidation? I'm only saying that in case we, in some of the cases, we sell some of the assets and we kind of start paying from those who are very low in section 53, and we are not paying as per priority, as per the priority under section 53, and then later on it may lead to insufficiency of the funds, and that actually will become preferential transaction. Now, what I'm trying to say, that the liquidator starts distributing, assuming that everyone will get, and first the corporate person will say that we are selling these assets, so you first pay to the unsecured loans of the family members of the directors or the promoters, and we will pay later to the banks and the secured creditors. That is something which is not permitted. The liquidator has to do the distribution as per section 53 and not in any other manner. Even if it is approved by the corporate person, the liquidator has to see the compliances of the law very carefully. It is also the duty of the liquidator to sell the assets and to recover and realize all the assets in time-bound manner for maximization the value. Realization of uncalled capital is very important under this voluntary liquidation. The liquidator shall realize any amount due from any contributory to the corporate person. The liquidator shall call and realize the uncalled capital and collect the arrears, if any, due on calls made prior to liquidation commencement date by issue of notice within 15 days from the receipt of the notice. No distribution shall be made to contributory unless he makes his contribution to unpaid capital. It is assumed that in most of the voluntary liquidation assignments, the distribution would be done to the shareholders also. So it is very clearly mandated by Regulation 33 to liquidator that in case contribution is not coming from the shareholder against unpaid capital or uncalled capital, then no distribution would be made to him till the time that contribution is made by that shareholder. So the bank account also would be required to be opened. So the liquidator will open bank account. The distribution after realization of the proceeds, the liquidator shall distribute the same within 6 months from the receipt of the stakeholder. So in this proposed amendments in the voluntary liquidation process, this period of 6 months is also reduced. In that case, I think it is reduced to two circumstances. One is the 1 month and then the 3 months. If the asset cannot be realized because of its nature or its other circumstances, the liquidator can distribute it as such after the company's approval. The asset can be distributed. If there is an immovable property, that immovable property can also be distributed to the shareholders. So that is also done. The return of money, and that is the same regulation as we have in liquidation process regulations, where if the entitlement changes, then that money can be returned after even distribution. Although it is said that the liquidation would be completed within 12 months from the liquidation commencement date, and what if the liquidation continues after 12 months. There is a regulation 37 sub-regulation 2. The liquidator shall hold a meeting of the contributories. Now the contributories in this case is the shareholders within 15 days from the end of 12 months from the liquidation commencement date at the end of every succeeding 12 months till dissolution. So every 12 months, the liquidator will have a meeting of the contributories, means shareholders, and will get an extension. The liquidator shall present annual status report indicating progress in the liquidation. That's what is regulation 37.1, 37.2, 37.3. So this is what is the duty of the liquidator, that to complete in 12 months. In case not possible, then hold a meeting within 15 days from the end of 12 months, present the annual status report, and keep extending it without any other impact. On the completion, the final report shall be submitted to NCLT, to the registrar of the companies, and also to the IBBI, and the final report shall consist of audited accounts of the liquidation. Now, in the liquidation process, the auditing is not required. However, in the case of voluntary liquidation, auditing of the accounts is required. Statement demonstrating that the assets has been disposed of and the debt has been discharged and no litigation is pending against the corporate debtor or corporate person. So this is very important, that we need to see in the final report, it has to be seen that no litigation is pending against the corporate debtor. So in case any litigation is pending, it will continue. Sales statement in respect of all assets containing the realized value, cost of realization, manner and mode of sale, the person to whom the sale is made, any other relevant details of the sale, that all is required to be part of the final report. Order of NCLT shall be forwarded to the adjudicating authority with which the corporate person is registered within 14 days. Adjudicating authority is not correct here. Authority, it is only the authority, means ROC. So it will be presented, it will be submitted to the ROC after within 14 days when the adjudicating authority passes a final order of dissolution of the company. So this regulation 39 talks about the unclaimed dividend, which goes to the corporate voluntary liquidation account as managed by IBBI, operated as part of the public accounts of India. That is, in case hardly we would see anything in such cases. In the voluntary liquidation cases, unclaimed dividend or undistributed proceeds would not be a very frequent scene. Now this is something that we have to read very carefully. The detection of fraud, regulation 40 says, if it is detected that the voluntary liquidation process has been initiated to defraud a person or the corporate person, or it will not be able to pay its debt completely from the realization of assets, the liquidator shall make an application to the adjudication authority to suspend the process of liquidation and pass appropriate order. Now that pass appropriate order, this is something which is very much important. It is the responsibility of the liquidator to file an application to the adjudicating authority, informing the adjudicating authority that the company is not able to discharge all its obligation, the assets are not sufficient, or there is any other event which has happened. So the appropriate, it will be a kind of appropriate orders. Now, these appropriate orders can be many kind of order according to my understanding. That is regulation 40 says it is only appropriate orders. To my understanding, the NCLT can even say that it automatically leads to the CIRP, or the or there can be some undertaking from the board of directors that they would like to continue the company to run, they would like to do the business, or they would like to take up their responsibilities and obligations in the normal course of business. So the suspension of the liquidation process, and like company would continue as it is, and all the creditors will have normal course of recovery process, that is also possible. Now, intention to carry fraud has two things. One is the misappropriation of assets, presentation of false valuation of assets, dishonoring existing contracts, undervaluing or overvaluing assets, saving sister companies, These are many instances where the detection of fraud can be found. So in any of such scenario, in fact, we will discuss when the questions will come, I will talk about it, what are the kind of frauds which are possible where some voluntary liquidation process is started. And then the application to adjudicating authority for appropriate orders and what kind of orders would be possible. Suspension of the liquidation process is one, and continuation of the company in a normal course. Somebody may apply for CIRP, and in that case, in case it is really seen that it is fraud, then appropriate action would also be taken against the person responsible for that kind of fraud. Again, the same requirement of keeping all the registers, books of accounts for 8 years, that is the preservation of records. Now this voluntary liquidation in case of pending liability litigation, if any, of the company, this is what is the most important question that everyone is asking. So we have now come to that question. If there are pending liability, if there are pending litigation, what will happen? So this is where we are now. And before I start this, and this is a very, very intense discussion, I would like to take up some questions, or I would see whether the Shalia can also answer some of the questions. However, this part, like uncertain liabilities and these perfect transactions, this is a very, very intense discussion. I would before I start this,
I think we can take the questions at the end of the session, because most of the questions will pertain or were pertaining to this issue, and once they are answered, then we can take up other questions that remain.
All right. So let us again reiterate what are the prerequisites of voluntary liquidation. One is the declaration by majority of directors or partners. What is the declaration? That the company has no debt or it is in position to pay all the debts. The company is not being liquidated to defraud any person, and in case the company owes any debt, the creditors representing 2/3 in value of the debt shall also approve such a resolution. This is a prerequisition. Now, the regulation 38 of the voluntary liquidation proceedings says the main ingredients of voluntary liquidation is that there should be no pending litigation, and the debt of the creditor should be discharged to their satisfaction. So discharged to their satisfaction is one very, very important part. Discharged and no pending litigation. So I actually have seen, I mean, there are some voluntary liquidation cases where I feel that it may continue for years. So in this case, NCLT Kolkata has passed an order in the case of Central Inland Water Transport Corporation Limited. And the facts of the cases are that the liquidator filed application under Regulation 40, subsection 2 for suspension of voluntary liquidation on the grounds of pending litigations and claim against corporate debtors exceed value of assets. Now, in this case, the observations was the corporate debtor has several pending litigations, and non-pendency of any litigation is a prerequisite for the voluntary liquidation. Liquidator failed to prepare final report because of pendency of litigation against the corporate debtor as per Regulation 38(1). Early liquidation can be done only in case if there is no litigation pending against the corporate debtor. And finally, what was held? Voluntary liquidation of the corporate debtor was suspended as the prime requisite of the voluntary liquidation process were not complied with. Now, when it is suspended, that means that the Central Inland Water Transport Corporation, the corporation, that would continue, and the liabilities and the assets, all the creditors will have their own recourse. Somebody will go to court, somebody will go to CIS and file CIRP, and somebody might even say that it was an effort to defraud us, and somebody might even say that it was a case of the intent was to defraud the creditors. And when we say the withdrawal or suspension of the voluntary liquidation process, so this is something that we wanted to discuss. In a dynamic economic environment, there could be instances where the corporate person initiated the voluntary liquidation process when the financial prospects were on downside. However, later, a fresh business opportunity arises, or management of the company considers selling it as a going concern to fetch higher realization. So this is also, there is a possibility that somebody withdrawal is also required. So some new opportunity has come after the voluntary liquidation started, or the management thinks that there is a person who actually would like to buy the shares of the company and somebody would like to take over the company. In both of the above circumstances, the corporate person would have to be revived. But the provisions of the IBC and the voluntary liquidation regulations are silent on withdrawal or closure of the process after its initiation. However, the honorable courts, in view of the revival of the company, have allowed the withdrawal or suspension of the voluntary liquidation process. Some of the cases discussing the withdrawal are discussed here under. So now what we are saying, two. One is the suspension and the other is withdrawal. I think this was a very important, suspension and withdrawal. Withdrawal, where even the board of directors are saying that we would like to withdraw. Suspension, where the liquidator is filing an application that the circumstances have changed, liabilities have increased, assets have reduced, or the liabilities are not being closed or crystallized. Therefore, the suspension. Now, these are some of the cases which are not from the IBC. These are from the under the Companies Act, and these are older cases. This is before even this IBC started. Dankari Investments Limited versus Official Liquidator, 2006 judgment of Allahabad High Court. Power to stay the voluntary winding should be exercised sparingly and only where it is just beneficial and expedient to do so, taking into consideration the object of formation of the company, the resolution of the differences, if any, the availability of assets in support of the resolution to continue with the business, the stage at which the management of the company is interested in deciding the process. So this is something which has been the kind of guidance that all this will be considered when the withdrawal of voluntary winding up or voluntary liquidation would be considered by the courts. Honorable courts should grant stay only when they are satisfied that the causes for which the voluntary winding up resolution was passed, if any disclosed to the court, no longer exists. The company is not indebted and commercially solvent, and a bona fide effort has been made to revive the company. In order to create some checks and balances on the withdrawal of process, it is considered that the corporate person be allowed to resign the process by the same procedure as was followed to initiate it, that is approval by a special resolution passed by members and supplemented by approval of creditors representing 2/3 in value of the debt if no asset of the corporate person has been realized by the liquidator. Approval of unpaid creditors unless the dues of all unpaid creditors are settled before passing of the resolution. The application for withdrawal filed by the liquidator before adjudicating authority should be accompanied with an affirmation by the liquidator that the due process for closure has been followed and the closure is not initiated to defraud any person. So now this is something which is considered to be withdrawal. For withdrawal, what is recommended by the high courts earlier in the Companies Act? One, that the same process under which the voluntary winding up initiated, that should be followed for even withdrawal. What was that process? A board of directors resolution, a special resolution by the members, approval of the creditors, and in this case, even the approval of the unpaid creditors. Even during the voluntary liquidation, voluntary winding up, if there are still people who are unpaid, either they are settled or their consent or approval is required for withdrawal of the voluntary liquidation process. So this is something which is actually like eye-opening, that this kind of cases had happened in the past, and similar circumstances can also appear in voluntary liquidation cases, where the decision can be withdrawn by the board of directors, by the shareholders, or the circumstances is such that the liquidator would say that this liquidation process be suspended and let the company go back to the normal process, or in case of some fraud or in case of some kind of defaults, then even the CIRP can be initiated. That also is possible, which can be done by the adjudicating authority. Now, in another case, which is Anil Kumar Dua and others versus Gulshan Kumar Gupta, Icon Realtek Private Limited, it's NCLT New Delhi case in 2018. It is again under the voluntary liquidation under IBC. The company was already under voluntary liquidation. Liquidator received the letter from the stakeholders expressing their interest to withdraw the voluntary liquidation process. Observations. The court observed that no dues or any other claims and the entire assets of the company have been kept in a fixed deposits with the bank. Liquidator has no objection for the present petition being allowed, and there no legal impediments is in allowing the prayer made by the shareholders and directors of the company. Therefore, the withdrawal of voluntary liquidation was admitted. It was NCLT New Delhi. Now, again, I think one of the very old case, which is VB Purohit versus Gadag Jambukeshwara. It is a Karnataka High Court case in 1984, which is a very old case. And the applicant with other shareholders decided to revive the company in extraordinary general meeting resolution to be revived that was passed. Petition under section 518(466) of the Companies Act filed for obtaining a permanent stay of voluntary winding up proceedings. Observations of the court was, if the shareholders have resolved to revive the company and make one more effort to start a cement factory, opportunity should not be denied to them. So this is something regarding the suspension, withdrawal, where I think a lot of participants would have some questions on this, how the changed circumstances can be dealt with, And now we would actually now reach out to the income tax part of it. Income tax, when we talk about income tax, we also include the direct taxes, and that may be GST, or that may be service tax, or that may be excise duty. So whatever that be, it will be applicable here. However, in income tax, we have section 178, which specifically handles the companies under liquidation. This has been a very kind of controversial issue so far, like whether the no objection certificate or no due certificate is required from the income tax department and in the voluntary liquidation cases. Now let us say the provisions of the income tax. What does it say? For any company in liquidation, income tax returns has to be filed and tax needs to be paid in accordance with section 175 in the Income Tax Act 1961. And this is applicable to voluntary liquidation, not applicable to the liquidation cases. This section obligates a liquidator to fulfill certain income tax related requirements. The section explicitly also states that its provisions shall have effect, notwithstanding anything to the contrary contained in any other law for the time being in force, except the provisions of the code. Regulation 14 of voluntary liquidation regulation mandates the liquidator to make a public announcement within 5 days of his appointment, calling for submission of the claims by the stakeholders within 30 days. Regulation also obligates all the financial creditors, operational creditors, including government and other stakeholders, to submit their claims within the specified period. If the claims are not submitted in time, the corporate person may get dissolved without dealing with such claims, and such claims may consequently get extinguished later on. Now, IBBI observed that the liquidators had been seeking NOC certificates from tax authorities, even though the code or the regulation did not ask for such a requirement. The process of applying and obtaining such NOC or no due certificate from the income tax department consumes substantial time, and thus militates against the express provisions of the code, and also defeats the objective of time-bound completion of the process under the code. So therefore, the IBBI came out with a regulation, which came out with a circular on 15th of November 2021, and clarified that as per the provisions of the code and regulations read with section 178 of the Income Tax Act, An insolvency professional handling voluntary liquidation process is not required to seek any NOC or no due certificate from the income tax department as part of the compliance in the said process. So this was the income tax matter, and in that case the IBBI has already clarified that it is not required. However, the matter is still pending. In case there are assessments pending, in case there are appeals pending, whether the company can be dissolved, that matter is still pending, and that is something which is the pending the frauds, pending assessments, pending appeals. That is the only thing that we are going to discuss now. So this is another case where we have some like kind of understanding from the case laws. Consul Hosiery Exports Limited, September 2019, NCLT Delhi. In a meeting of the board, a resolution was passed to initiate voluntary winding up of the company and for appointing a liquidator, as no business was conducted by the company from the past 2 years and no income was being generated except from investments, and subsequently the liquidator was appointed. The liquidator gave the required intimation under section 178 of the Income Tax Act with income tax authorities on June 2018. Further, the liquidator made the payment for dividend distribution tax. Due to non-receipt of income tax refund for the assessment year 2018-19, the final report could not be submitted within the stipulated period. In view of the same, as provided in Regulation 37, a meeting of the stakeholders was convened within the directors, and liquidator prayed for extension of time for the submission of the final report. Accordingly, in terms of Regulation 38 of the IBB regulation, the voluntary liquidator submitted the final report to IBBI on July 2019 in E-form GNL2 dated July 2019. Now, the issues in this case, issues in Consul Hosiery was whether during pendency of assessments, non-receipt of income tax refund assessment, voluntary liquidation process be extended or time be granted for submission. Now, what was held? ROC deposed that the company was fully solvent and was not being liquidated to defraud any person. The liquidator has filed affidavit confirming that neither he nor company has received any objection regarding the present liquidation proceeding of the company from any person or authority whatsoever. Necessary compliances of section 59 and other relevant provisions of the code read with the regulations have been made within 12 months from the date of the fresh extraordinary general meeting convened on June 2019. Liquidator in affidavit proposed that after liquidating the assets of the company and paying off all the dues, he has distributed all the proceeds to the shareholder and has closed the account. In view of the foregoing steps taken and the satisfaction accorded by the voluntary liquidator by way of present application, there is no legal impediment in allowing the prayer of the applicant. The said company is hereby dissolved with effect from the date of the present order. Thus, despite the IT assessment being pending, the company may be dissolved if all legal formalities have been complied with. So this has been a case in 2019 by NCLT Delhi, where the company was dissolved, whereas the adjudicating authority had complete information that the assessments are pending and the income tax refunds are also pending, and the company was dissolved. However, when we see the provisions, when we look at the provisions, we also see that the it should have been provided for. My opinion is that it should have been provided for in case the shareholders has taken the distribution, and in case in future any kind of demand is raised, and if it is payable, the shareholders should have been made responsible for making the payment of such cases. Like the Supreme Court in one of the cases, Commissioner of Income Tax Madras versus Express Newspaper Limited, that's very old case, 1965 Supreme Court case. Rather, a company whose name has been struck off the rolls of the ROC pursuant to voluntary liquidation on and the which company filed a return of income on January 1948 and assessed to tax by order of assessing officer on like 2 years after the uh, 2 years after the voluntary liquidation, such an order of assessment was valid. Argument. The learned counsel for the assessee argued that the assessment could not be held to be invalid for the mere reason that the company was not in existence on the date of assessment. What was held by the Supreme Court? The existence of an assessee is essential for an assessment. There cannot be an assessment of a non-existent person. The present case, the assessment was made long after the company was struck off from the register of companies and it could not be valid. So that is something which is absolutely acceptable, that the assessment has to be done for an existing person. So the company is a judicial person. So in case the judicial person is not existing, then no possibility of any assessment. So I think, Ankit, anything that we would like to discuss on it here? Like now we will actually go into the avoidance applications, and Lisa, see if there is relevant questions here, and then for the avoidance applications we'll just go for
so we're running out of time. Maybe we can take up the avoidance applications and then wind up. We're already 15 minutes up from the scheduled time. So I think this topic, as any other topic, is vast in itself. So it always takes more time than what we budget for. So let's talk about avoidance transactions quickly.
No, we have attended suspension. We have attended.
Yes, we have attended a lot of issues. We have attended a lot of critical
income
issues.
tax pending litigation.
So I believe almost all questions have been talked about and answered. We can take up the avoidance applications and then maybe ask the participants to post any questions that they have which are not yet answered. We will take up those questions.
Okay, as far as this avoidance transactions are concerned, this section 59 subsection 6 of the code says that the duties of the liquidator appointed under the voluntary liquidation will be the same as that of the liquidator as ordered by the court. The purpose of determining avoidance transaction is to provide equitable treatment to the creditors as provided in section 53 of the code. It is very clearly said that section 35 to section 53 will apply to voluntary liquidation cases as well. Hence, any transaction under section 43 to 50 will be reported by the liquidator. Practically, if all the debts are being paid, then section 43 would not be applicable to debts. Practically, if all the debts are paid, then section 43 would not be applicable, because if everyone is paid, then there is nothing like preferential transaction, or nobody would be aggrieved that somebody is paid and on a loss to me. The priority was mine, but somebody else has been paid. However, the similar section 49 transaction would also in preferential transaction, the shareholders also would not have objected to it. However, in the case of undervalued transaction, it may impact shareholders. Now, in case the board of directors try to sell the assets of the company at a value which is much lower than the market value, then the amount which is payable to shareholders will actually be reduced. Although the company is paying its debt, but the amount payable to shareholders will be adversely impacted in case the assets are sold at a lower value. In a recent case, somebody asked me a question that while the voluntary liquidation is going on, the company, the management of the company, they were directing the liquidator to make some payments. Now, the liquidator, who is my partner, he asked me, what is his responsibility? Then I said two things. I said, one, to protect the assets of the company is your duty. Number two, in case you are looking at something that some money is being paid and the value is not being received, like it was a case that some amount is being paid to some professionals, and the liquidator was not satisfied whether these professionals actually have rendered those kind of services. So then the liquidator thought that this is something which is the kind of excessive billing which is being done to take away some money. So I said that liquidator's duty is to protect the assets of the company, and in case all these diversion, all this siphoning of money will actually impact the amount payable to the shareholders. Therefore, Section 45 is applicable. It is it is actually the duty of the liquidator to identify and determine the avoidance transactions and make application to adjudicating authority, as Section 43, 45, 49, 50 of the code is applicable to voluntary liquidation processes. The liquidator assumes control over the company and its assets from the liquidation commencement date. Prior to this date, it is the management of the company which remains in charge of the affairs of the company. Thus, the possibility of avoidance transaction cannot be ruled out. When we see this reading of Section 59(6) with avoidance transactions like 43 to 51, it suggests that it is incumbent upon the liquidator appointed for voluntary liquidation to form an opinion and make a determination to identify the transactions under these sections of the code. Thus, the liquidator in avoidance transaction sections shall thereby mean include the liquidator appointing for the voluntary liquidation transactions. The liquidator is under a duty to determine the avoidance transaction and file appropriate application before the adjudicating authority. The existence only in the liquidation, the harmonious construction. I think this is now very clear that this is required. This is required that the avoidance transactions are applicable. Now, can a company be dissolved during pendency of adjudication of avoidance applications? Now, let us see Regulation 44(1) of the liquidation regulation, which reads as: the liquidator shall liquidate the corporate debtor within a period of 1 year from the liquidation commencement date, notwithstanding pendency of any application for avoidance of transactions under Chapter 3 of Part 2 of the code. I am reading the liquidation regulation. It is not voluntary. It is not voluntary liquidation regulation. Now let us see Regulation 38 of the voluntary liquidation regulation. Now, Regulation 38 says, on completion of the liquidation process, the liquidator shall prepare a final report consisting of, and inter alia, this is one of the line, no litigation is pending against the corporate person. This is a declaration which has to be made by the liquidator, or sufficient provision has been made to meet the obligations arising from any pending litigation. So in case sufficient provisions are made, then the liquidator can apply for the dissolution of the company, and in the final report, the litigation, he can say that no litigation, or he can say that the sufficient provision has been made to meet the obligation arising from any pending litigation. So the similar declaration is also incorporated in that proposed certificate, which is compliance certificate, which is supposed to be given by the liquidator in the case of voluntary liquidation assignments in their final report. So when we see this Regulation 44 of the liquidation regulations and Regulation 38 of the voluntary liquidation regulations, now we can actually see, that liquidator can mention in the final report that no litigation is pending except application for avoidance transaction. Thereafter, it is left to the discretion of the adjudicating authority to decide whether to close the liquidation or to keep it open till final decision. So if the sufficient provision is made in the final report, and then what can be those provisions? The provision can be that such and such person has taken the responsibility to handle these avoidance transactions, and whatever would be the outcome, that would be distributed in this manner. So that can be the sufficient provision, and also some kind of liquidation cost can be earmarked for that. So this is what is my understanding on this voluntary liquidation. Among this 1 or 2 slides that we have prepared, because this IBBI has issued a discussion paper on 1st February 2022, and it was the intent of the discussion paper is to reduce the timelines and also to introduce a compliance certificate, which more or less it's basically indicating that the more than 52% of the ongoing cases has crossed 1 year. So the IBBI is trying to reduce the timelines. So all these are okay. All this is kind of welcome changes which are being made. Then the it is also said that the role of the adjudicating authority is limited, but what we have seen that the role of the adjudicating authority is very, very important in the case of suspension, in the case of withdrawal, in the case of dissolution, in the case of avoidance transactions, and how to decide the pending litigation and how to find out the frauds. All this is a very, very important as regards the role of the adjudicating authority is concerned. However, the stakeholders in this case are like the company, the management of the company, the board of directors, they would conduct the process. The liquidator would definitely conduct the process as per the regulations. The liquidator has got all the responsibilities. The liquidator would certainly comply with all the provisions. Now, I think, Ankit, we have reached to this the Companies Act versus voluntary liquidation. So quickly, we can just in 5 minutes we can do that, and then probably the 2 hours would be well, we'll just manage it in 2 hours. Although this is too long, but it is not possible to have 2 sessions on voluntary liquidation.
So strike off. Yeah. So strike off is prescribed under section 248 to 252. Now, the Companies Act says that the conditions in which the strike off can happen are twofold. Either the registrar can do it on their suo motu basis, or the company can also, or the company's rather, I would say, contributories can also apply for a strike off. The first instance when it can be done is when the company has failed to commence its business within 1 year of its incorporation. The second is when the company is not carrying on any business or operation for a period of 2 immediately preceding financial years and has not made any application within such period for obtaining the status of a dormant company. The third is the subscribers to the memorandum have not paid the subscription which they had undertaken to pay at the time of incorporation of a company, and they have not filed a declaration to this effect. So within 180 days of the incorporation, then the company is not carrying on any business or operations as revealed by the physical verification carried on under the provisions of the Companies Act. Then any company, these are the provisions under which the registrar can then strike off the company suo motu. Any company which may, after extinguishing all its liabilities by a special resolution or consent of 75% of their members in terms of paid up share capital, can also file the application in the prescribed manner to the registrar for removing the name of the company from the register of companies on all or any of the grounds which are specified, which I just talked about. So these are the cases, these are the scenarios when a strike off can be done by a company. This is what needs to be established by the company, that we are eligible for strike off in these circumstances. What happens in a strike off is that the company's names is just striked off from the register. So we are meaning to say that no transfer of assets happens. Now carried forward losses of the company are carried forward or given to somebody else. The business is not sold to somebody else or transferred to somebody else. The assets of the company are not handed over to settle the liabilities in this process. So the whole process which the company goes through in a strike off is a very tax inefficient way of closing the company, especially where the tax efficiencies are required. Or when in case of voluntary liquidations, we say that one of the major reasons we go for voluntary liquidations is that, say, an asset is there in the company's name, the asset is no longer required to be in the company's name for the business of the company, so it can very well be transferred or sold off in the market or transferred to the shareholders or the stakeholders of the company, especially where the liabilities are not there, or transferred to somebody who is liable to be paid by the company. So those scenarios then make it a tax efficient transaction, because the company in that case is not paying a dividend. It does not have to pay, the shareholders do not have to pay dividend tax. They only need to talk about the capital gain taxation when they receive the asset, which is compared with the investment that they had in the shares of the company. Now, this is the strike off case. I have also briefly talked about the voluntary liquidation and when that, how that is maybe better in as a strike off as compared to strike off. And there will be many other circumstances that voluntary liquidation is applicable or available to the company, but strike off is not applicable because the company is not covered under any of the provisions that I just talked about. In case of winding up provisions which are contained in chapter 20 of the Companies Act, There, the company can, by special resolution, it can resolve that the company can be wound up by the tribunal. And if the company has acted against the interest of the sovereignty and the integrity of India, that is a case where the tribunal can suo motu, or the central government can apply to the tribunal and say that please wind up this company. This is against the interest of the country. Similarly, in case there is the company has been conducted in a fraudulent manner, or the company has formed for fraudulent and unlawful purposes, or where the default in filing with the registrar its financial statements, so annual returns are not being filed, financial statements are not being filed, or where the opinion of the tribunal is that it is just and equitable that the company should be wound up. So in these circumstances, there is a provision in Companies Act under Chapter 10 for the company to be wound up, and that is available with the company. Voluntary liquidation under the Insolvency and Bankruptcy Code is again an option where the company can suo motu go to tribunal without all these reasons affecting the voluntary liquidation. And of course, as I said, that is more tax efficient, that is quicker, that is the objective, that is how that process is different from winding up under Companies Act under Chapter 20 or strike off under Chapter 18.
Thank you, Ankit. So there are a couple of questions which are very quickly answerable, like whether CIRP power of directors are suspended under the voluntary liquidation or not. As I said, the powers of directors are not suspended. However, the members of the company, when they are passing the special resolution, they can say that whether the liquidator will work independently or the liquidator will work with the consent of the board of directors. That is within their power to do that. And also there are questions, can an asset, say land, which is readily sellable, be distributed to the shareholders? If yes, what will be the procedure? Yes, the land can be distributed to the shareholders in case all the liabilities are paid. And if there is still a land available, the land can be sold to the shareholders. Whatever the transfer formalities are under the Transfer of Properties Act, that has to be done. Stamp duty has to be paid.
It would be transferred, not even sold, but whenever it will be transferred, stamp duty will be applicable. But yes, there is a provision in the Income Tax Act which allows for the receipt of this land to be received against the cost of acquisition of the shares, in effect not making the dividend distribution or the dividend tax applicable on the assessee who is taking this land. It will become a capital gain transaction, making it more tax efficient.
Yes. Then there is a question anyway, but the time is like, can the liquidator pay salary to the employees and remuneration to the directors during the liquidation period?
We've answered all these questions.
We have answered all the questions.
So I think if there are any further questions that perhaps we have not been able to answer, you can always write to us. I believe our email addresses, our contact details were available in the brochure that we sent out. We'll be happy to answer those questions. And I believe it's already 2 hours. So I hope this was helpful for everyone. And Shalia, anything that we think is very important to be talked about that we might have missed that you would like to add?
No, so I think we have added, said about everything which is relevant under voluntary liquidation, and we could reply to all the questions through our emails. So there are many questions which needs to be answered, so we can do that through emails.
It was a wonderful research done by Shalia, and a lot of case laws, and also the case laws under the earlier Companies Act. That was really helpful to understand the suspension and withdrawal part of it. It was also very important when we actually saw the Supreme Court order, where it was held that no assessment can be done for a non-existing person. That was also really helpful. Considering this, I would have only one opinion, that in case the litigations are pending, in case the assessments are pending, then it is always advisable that the adjudicating authority should see what are the provisions made. Otherwise, this may lead to some kind of fraudulent transactions where some people may even go for voluntary liquidation while they foresee some kind of huge demands are coming against them from either for direct taxes or for indirect taxes. So the adjudicating authorities should try to see whether the provisions has been created or who would be responsible for these demands in case the money has been distributed to shareholders. Thank you very much, Ankit, Shalia, for all this hard work. Thank you very much to all the participants who are connected with us. In fact, when we see the response, in fact, we got too many registrations this time, and it was really a pleasure for all of us to present our experience before you. And I always say that there is no other objective. This is my way of learning. This is our way of learning. Thank you very much. Thank you very much.
Thank you, everyone. Thank you so much.
Thank you.
Thank you.